Claim for necessary goods supplied even by an interested person. Obligation of a person during manufacturing non-particular state responsibility of finder of goods section 71. Money may paid by mistakes or under provision section 72 under the provision of the method by relationship of quasi contract is deemed quasi contract is deemed to have come to exist in five different circumstances which will be presently dilated upon, but it may be noted that it none of these cases dare come into existence by any contract between the parties in real sense due to penicular circumstances they placed the law purpose. In which of the following cases the contractual liability claim for the necessity supplied to a person incapable of contracting section 68. If a person incapable of entering into a contract or anyone who is legally bound to support is supplied by another person which with necessary entering into contract or anyone who is legally bound to support is supplied by another claim for necessary reply to a person capable of contracting section 62 of person capable of entering into a contract or anyone who is legally bound to support it supplied by a person with necessity suit to his conditions in life whose condition of the person who is furnished such applies with matter will be reimbursed from the property of such a person who establishes claim the supplier must prove not only that the goods were supplied to a person who was a minor or lunatic but also that they were suitable to his actual requirement at the time of the sale and delivery. The payment by an interested person, a person who is interested in the payment of money, which is by law to pay and who therefore pays it is entitled to reimbursed by other. Obligation of person enjoying benefits on non-gratuitous taxation in the terms of the contract. Obligation of a person enjoying benefits of non-gratuitous act. Non-gratuitous act or person enjoy in the terms section 70 of the act where a person lawfully does anything for another person or delivery anything to him not intending to do so gratuitously and such other person enjoy the benefits thereof. Also, the latter is bound to pay compensation to the former in respect of or to restore the things so done. It thus follows that for a suit to succeed, the plaintiff must prove that he had done the act or had delivered the things lawfully, that he did not do so gratuitously, and that other person enjoy the benefit. The above can be illustrated by case actual law, where K is a government servant, compulsory retired by the government. He filed a right petition and obtained an injunctions against the order. He was restrained and was paid salary, but was finder of lost goods. Hello, people. The following responsibility of find out possible a person who finds a goods belongs to another and takes them into the custody and subjects to the matter. Find belongs to another takes them to the custody and subjects to the same responsibility as if both are available. Thus, the finder of loss would have to take care proper of the property as a man of ordinary prudence would take no right to appropriate the goods and to restore the goods in the way is bound in Holland versus Holler, LR and HL has picked up a diamond on the floor. सब हो गया था भाई मेरा. Money paid by mistakes or fraudulent section 72. A person whose money has been paid by anything delivered by mistakes or under provision must repay it or return. Every kinds of payment or delivery of goods, every type of mistakes is recoverable. Similarly, any money paid by courier is also recoverable. The word coercion is not necessarily governed by Section 15 of the Act. The word is interpreted to mean that includes obsession, extortion in such meanings as the means Seth Kanji Lal versus National Bank of India. In the case T of quasi-contract and contract, the credential of the formation of valid contract are also essential to for a valid contract are present. Law enforced by law created by consent of the parties. Contract of indemnity and contract of guarantee now start this contract of indemnity and contract of guarantee. Contract of indemnity and contract of guarantee specifies types of contract provided under Section 24 and 4147 of the Indian Contract in relation to the specific provisions. That is Section 24 to 147 of the Indian Contract Act. The general principle of the contract are also applicable to such contract even though both the contract modes are compensation based or similarly principle different financial driven in several aspects. Contract of indemnity, the term indemnity gets criminal security against loss or to make the loss or to compensate the party who has suffered same loss. The term contract of indemnity is defined under Section 124 of the Indian Contract Act 1872. It is a contract by which one party promises to save others from the loss caused to him by the conduct of the promise himself or by the conduct of other person. contract of indemnity defined in the section. The term indemnity means literally against the laws to make good the laws to compensate the party who has suffered some loss. The contract of indemnity defined section 124 the Indian contract act is related to what the provision is able to say from the loss caused to him by the conduct of the promisor himself or by the conduct of any other person. The party who promised to indemnify save the party from the loss called indemnifier. The party who is promised to save against the loss called indemnified or indemnity holder. However, the provisions of definition of indemnity restrict the scope of contract of indemnity as much as it is cover only the loss caused the conduct of the promisor himself or conduct of any other person. Thus, loss occasioned by an accident not caused by any person or an act of God, natural event is not recovered, not covered. In the case Ganjan Moresh versus Moreshwar Madan, decisions is taken on the basis of English law. As per the English law, indemnity means promise to save other harmless from the loss. It is covered whether due to negligence of promise or by natural calamity or by accident. Modes of contract of indemnity. A contract of indemnity, like any other contract, may be expressed or implied. A contract of indemnity is said to be expressed when a person expressly promised to compensate the other from loss. A contract of indemnity is said to be implied when it is to be inferred from the contract, the conduct of the parties, or from the conduct of the case. Right away indemnify holder when sued section 125 the promise of the contract indemnity acting within the scope of authority implied authority. Implied authority to recover from the promisor or indemnify all damages may be compelled to pay in a any suit. All costs may be compelled to pay in the beginning defendant the for the suits and all sums which have paid under the terms of any compromise of suit. And thus the liability of any fact commenced. Although the it is silent on the time of commencement of liability of indemnifier. On the basis of this judicial pronouncement, it can be related that the indemnity of indemnifier commences as soon as the liability of indemnifier holder becomes absolute and certain. The principle has been followed by the court in several cases. Contract of guarantee, surety, principal letter. Surety person who gives the guarantee. Principal letter person who is the false guarantee is given creditor. Person who guarantee is given. It is quite important. Promise to compensate other from the loss of contract of administrative and private cases to ensure from the conduct of the parties or from the circumstance of the case. Right to indemnify other than shield the promise is a contract of indemnity is properly authority and matter from the foundation. All damage which may be compared to paying when she all cost which all sum which he may have paid under the terms of the compromise exchange. When does the liability of the frank run? All costs which may have been compared to paying the bringing, defending or suits, and all sum which may be paid under the terms and compromise. When the liability of an enemy fact about all the things that is signed and term of management of liability of an enemy fact, however, in the principle judicial pronoun, it can be stated that the liability of an enemy fact common action as the liability of an enemy fact is become absolute and certain. Contract of guarantee. Contract of guarantee surety principal letter and creditor. Contract of guarantee. Contract of guarantee is a contract to perform the promise made or discharge the liability of the third person in face of his default. Surety person who gives the guarantee with regard to person does not guarantee person who gives the guarantee of guarantee. The guarantee is a triparty agreement. Three-party agreement. The right of surety is not affected by the fact that the creditor has refused to sue the principal debtor or that he has not demanded some due from the guarantee. Contract of guarantee. Tripartite agreement. Principal contracting. Contract. Secondary contract and client contract. Principal letter. Creditor, surety, principal letter. The following are the requisites of a valid guarantee purpose. The purpose of a guarantee paying is to secure the payment of a debt. The persistence of the probable that is necessary in principle that there can be no valid guarantee